I was not driving. I was not operating. I was traveling in my mode of conveyance. I answer to God and God only.
I've already made a record that the court can prosecute.
That's not a ruling.
That's an ignore.
All right, I'm going to call Charles Schmidt, 25M4346. And Mr. Schmidt, if you could take a seat at this table. We are set for a motions hearing today, and I know that the prosecution has objected to the court addressing these motions, but based on the record, I will allow for argument and, if necessary, testimony regarding those motions. So I think we'll just take them one at a time. Do you have any questions, Mr. Schmidt, about the process we're going to follow today?
No, ma'am.
Okay. I'm going to make sure that I'm keeping a real good record of this. So I just want to make sure there was a motion for an interlocutory appeal that you wanted to appeal that to a higher court, some of which I think was discussing that you were unhappy with the Judge Burbach's rulings on whether you would get that addressed. Do you still want to make an argument regarding the motion for an interlocutory appeal?
Yes, ma'am.
Okay. All right. I'll give you 3 minutes. Go ahead.
What was the charge that I was pulled over for?
So I mean, this isn't going to be a back and forth. So you can make an argument and then I'll hear from the prosecution and then I'll rule.
I have no idea why I was pulled over.
Okay. Do you want to make any other argument on this motion for an interlocutory appeal? You have about full 3 minutes.
The fact that I was not being represented by Constitution. I do have co-counsel with me at present who is a bar attorney and my tribal elder. He has a federal bar card. And the fact that the officer lacked probable cause on the stop to start with.
Okay. Mr. Eads, do you want to make any argument?
Your Honor, I just object to an interlocutory appeal in this case. I don't really think that there's any grounds. Generally, interlocutory appeals are reserved for when there's been some kind of order of the court, oftentimes like a prosecutorial motion based on like suppression of evidence or something of that nature. That's not really what we have here. I don't see that there is any real basis.
Based on my review of the authority, I don't find that anything has been presented that would allow for an interlocutory appeal. Where I'm ruling on them today, I'm giving you that opportunity to be heard. I'm giving you that due process. As far as the entry and not guilty plea on your behalf, the law does allow a judge to do that. There's a statute, and that's under Colorado law, and that's 16-7-208. Okay, so I know you object. I'm just going to, so I've given you a chance to speak, I'll speak, and then, and you can make any other further record. But that statute says that if a defendant refuses to plead, then the court shall enter a plea of not guilty. So the court has the power, the judge has the power to move a case along, even if someone doesn't want to enter into their not guilty plea. That is a process that under Colorado law we have. So it sounds like that has raised something for you, Mr. Schmidt. So I'll give you 2 minutes to make any argument on that.
I did not refuse. He did not supply a bill of particulars where I could make my argument in pleading to the court. I do not know what I was pulled over for. I was denied counsel. When I requested counsel, I was denied Miranda rights. I was not driving. I was not operating. I was traveling in my mode of conveyance that I'm entitled to have.
Okay. All right. So I'm going to make a ruling regarding this jurisdiction issue. So jurisdiction is used in this order, this finding relates to the power of a court to hear and decide cases involving violations of substantive criminal law. So again, it's been alleged that this occurred in Colorado. Therefore, the court has subject matter jurisdiction. Mr. Schmidt is here in front of the court. The court believes that it has jurisdiction over him. To any point that there might be that he didn't contract or any sort of UCC, I didn't see that in there, so I don't think I need to make a record on that issue, the Uniform Commercial Code. And so I do find that we do have jurisdiction over Mr. Schmidt, but Mr. Schmidt, I will give you 2 minutes to respond to the argument.
Authority do you have over Indians? I did not hear anything about Indians. under Yakima Indian Nation versus Flores, 955. F. Sup. 1229. E.D. Washington, 12 of February 97. Former Governor Stevens guaranteed that all Yakimas shall have the same liberties outside the reservation to pasture animals on land, not occupied, and on land not occupied by whites, to kill game, to go get berries, and to go on the road to market. I am free to travel, ma'am, period, by treaty. And that would be the Treaty of 1855. And I don't know that I have that number in front of me.
The tribe was recommended.
So where did y'all wind up with jurisdiction over us when our treaty was there before this was even a state? We were in the Northwest and recognized by the United States as treaty. Indigenous Indians. I am a member of the Pilchuck tribe. I'm being represented by council of the Kikialis Indian Nation.
Let me just pull up another case. There's a Colorado case, People versus Drew, 650 or 250 Pacific 3rd, 761. It's a Colorado Appeals Court case from 2010. And that talks about that these ideas that someone's a sovereign citizen, and I have a quote from a case that is actually a federal case that I find helpful in that guidance. Utah Department of Workforce Services versus GEDDES, and that's a 2013 Westlaw 1367025. That court said the sovereign citizen argument has been rejected repeatedly by courts. Simply by labeling oneself as a sovereign citizen, an individual does not immunize himself from the jurisdiction of the state or federal courts. Jurisdiction is a matter of law, state and constitution, wherein one's power is, and not a child's game, wherein one's power is magnified or diminished by the display of some magic talisman or use of special seals or by the recital of special words, phrases, or arcane incantations. Even though a defendant may have a sincere belief that he is an alien beyond the jurisdictional reach of the courts, in that case, they found he is simply wrong. Courts have routinely found that sovereign citizen arguments are completely without merit and patently frivolous. Thus, an individual's belief that status as a sovereign citizen puts him beyond the jurisdiction of the courts has no conceivable validity in American law. That's Charlotte versus Hansen, 433 FAPPX 660, 10th Circuit, 2011.
Sovereign citizen, that's an oxymoron. You can either be sovereign or you can be a citizen, but you cannot be both. I answer to God and God only.
Okay. All right. So I'll note that I've already made a record that the court can prosecute, even if you are in made a record regarding your tribal membership.
Okay, to start, can I have you state your full name into the record and spell your last name?
Chris Steiner, Steiner.
Thank you. And where do you currently work, Agent Steiner?
I'm a detective with the Arvada Police Department.
Okay. And how long have you been a detective for?
Been a detective since 2018. I've worked with the department since 1995.
All right. And what are some of the responsibilities that you have as a detective?
My primary responsibilities are crash investigation reconstruction and crime scene investigation reconstruction.
Now, are you able to make and initiate traffic stops as a detective?
I am.
Okay. And under what authority are you able to do that?
I'm still a police officer with the city of Arvada, and I'm also still technically assigned to the traffic unit.
Now, do you recall a traffic stop that you initiated on August 1st of 2025?
I do.
And what specifically did you see to cause you to make a stop there?
As the the seatbelt violation is a secondary offense. I had to observe something else occur. As Mr. Schmidt drove past me, I could see that he had a handicap placard swinging from the rearview mirror, which it can be an obstruction to your vision. And also saw that he was not wearing a seatbelt. After I got behind the vehicle, I also observed what appeared to be a fictitious license plate.
Now, you noted a fictitious license plate. Going through that real quick, what about it prompted you to believe that it was fictitious?
It was not a standard plate issued by the state of Colorado. It said Colorado on the top, but then I believe it said something like A and S on one side. The numbers weren't standard. Characters were not standard for Colorado license plates.
So would it be correct to say that it just didn't look like a Colorado license plate that would be issued by the state?
That's correct. Asked him for his license, registration, and insurance, and he refused to give them to me.
Okay. And so is this something that happens to you sometimes?
Very, very, very rarely.
What's the procedure in occasions where something like this does happen for you?
Usually we just keep asking and try to get, if they don't have a driver's license, we ask, okay, what's your name? And that type of stuff. And just try to get a verbal identification or something like that. He refused, saying that he wasn't my friend and that he wasn't driving, so he didn't have to give me anything.
Can you explain to me, how were you interacting with him throughout this?
I was standing outside of his vehicle. He rolled down the window about 2 inches and was talking to me through the window. Didn't provide me any information, and threw a large packet of paperwork at me saying I'd been served.
Did he give you any rationale or reason why he was refusing to comply with your request for identification?
He said he wasn't driving, that he was just traveling, so I couldn't stop him.
Was there anybody else in the vehicle with him?
There was not.
Was he in the driver's seat of the vehicle?
He was.
Had you seen him traveling or, operating the vehicle on a roadway?
Yes.
Do you know that roadway, who that was maintained by?
It's the City of Arvada roadway.
And so would that be a municipality?
Yes,
And he was the one that was in control of that vehicle?
he was.
In common parlance, would that be driving?
Yes.
So based on your observations and your own investigation, did you issue him a summons or a ticket?
I did.
And what charges were issued?
It was for obstructing government operations, failed to display valid registration, not wearing a seatbelt, no proof of insurance.
And was fictitious plates another one of those?
Yes.
And what was the basis for the obstruction of government operations?
Failing to provide information that we requested on the traffic stop, that being license, registration, and proof of insurance.
And did he provide any physical or other obstacles to you being able to conduct that operation, that traffic stop?
Refused to talk to me anymore. He had the VIN number blocked on the windshield, so we could not see the public VIN. Took the stop from what probably would have lasted about 4 minutes is my average traffic stop time to over 30 minutes and required three officers.
Officer Steiner, are you allowed to violate the law in order to enforce it?
At sometimes, yes. If I had to drive faster than the speed limit or something like that, yes.
So you're allowed to use an unmarked car for the sole purpose of pulling people over for a placard, where nowhere on it does it say remove while driving
Yes, I'm able to use an unmarked car to do traffic enforcement.
against federal law. Where was I stopped?
I'm sorry?
Was it a highway, a roadway,
You
byway?
pulled off of Lamar onto, I believe it's
So it-
56th.
So that is not a highway.
It's a roadway.
Right. I believe I have something that says all Indians have secured treaty right to travel upon all state public highways without being required to have a state-issued driver's license, license plate, or registration. Are you familiar, sir,
Your Honor,
with
object at this time to relevance as well as, I believe, a misstatement of the law.
So I'm going to let Mr. Schmidt finish his question and then I'll roll on your objection. So what is your question?
are you familiar, sir, with the Vehicle Anti-Theft Act?
So I'm going to find that that's not relevant to the issues of constitutional motions of whether there was reasonable suspicion to stop the car, probable cause, or the Miranda issue that's been raised. And so I will sustain that objection. Mr. Schmidt, today, all we're deciding are these constitutional issues of whether evidence can come into your trial. And so all we're focusing on is whether the officers complied with the Constitution. And so if Mr. Eads is objecting, I'll rule on those objections, but I want you to narrow in on those issues that you filed on that regarding those constitutional issues. Go ahead.
You say I did not offer you anything as evidence. Do you remember a blue folder that I handed you 3 times out the window? My dossier that had all that in it?
It was twice you threw a large packet of paperwork at me saying I'd been
3
served.
times.
Okay, Mr. Schmidt, you can't interrupt him because we do need to make sure the record's clear, okay? So go ahead, officer, and then I'll let Mr. Steiner finish his sentence.
Do you know what was in that dossier?
No, sir.
Did you open it and look?
It wasn't the driver's license, registration,
How do
or
you
insurance
know?
that I asked you.
Mr. Schmidt, again, you can't interrupt, okay? And so we won't get the record to be clear. So Officer Steiner, if you could just finish your sentence, please.
It wasn't the driver's license, registration, and insurance card that I asked for.
And how do you know this?
Because you told me I was being served, which to me appears to be legal documents serving me with some type of court document or something like that. That's not a driver's license.
So you're saying that the seatbelt was the probable cause in order to pull me over?
No, sir.
Is that an arrestable offense?
I did not say the seatbelt was the probable cause to pull you over.
Okay, so it's a secondary.
Correct.
Okay, what was the probable cause in order to pull me over?
The obstructed vision that could have occurred from the object swinging from the mirror, that being the handicap placard, and the fictitious license plate on your vehicle.
Do you have measurement or a photograph of this alleged swinging ADA flag hanging from the rearview mirror?
I believe it was captured on body camera.
And I bet it hangs lower than the sun visor that comes standard equipment with the vehicle?
Yes, sir.
No.
Because it hangs on the rear view mirror, which hangs down below the visor, sir.
Objection, Your Honor.
I'm going to overrule that objection because it was an answer to your question. And so I'd like you to focus on any other questions that have to do with that stop, probable cause, or the Miranda issue that you've raised regarding your statements.
I had requested counsel to be present. Do you remember me making that statement? And that I did not allow for any search or seizures of that car. I made that statement to both you and Officer Brown.
I'm going to object. This sounds like testimony. He's not currently on the stand.
Okay. Officer, did at any point he request an attorney?
Not that I recall.
Okay. Mr. Schmidt, any other questions?
Did you cite me for the other violation that I was alleged stopped for?
No, I didn't cite you for the handicap placard. I cited you for several other violations.
Which would be poisonous to the fruits of the poisonous tree. I yield. No further questions, Your Honor.
Okay. Thank you. May step down. Any other witnesses for the prosecution?
Yeah, at this point, I think we'll rest.
Okay.
We do have Sergeant Brown here, but I think they're sufficient.
Okay. Hold on a second, Mr. Schmidt. So the prosecution rests on the motions hearing. Mr. Schmidt, do you intend to call any witnesses that are relevant to the probable cause, the stop, and the Miranda issue?
Yeah.
Was that person present here on that day? Okay, so how would he?
By tribal counsel,
Okay,
expert witness,
for what?
tribe matters.
Tribal matters. So legal issues?
Yes.
Okay.
In particular.
So I'm making a factual finding today regarding whether there was reasonable suspicion, probable cause in that Miranda issue. Calling an expert, a legal expert, I'm going to base my decision on the law. You can cite the law, but you do not have an attorney that has entered their appearance formally, and they need to do that before they can represent you. If he's an expert, you can.
No counsel, ma'am, do not have to, according to the Sixth Amendment.
Yeah, well, under the rules of the Colorado Rules of Procedure, you do have to have an attorney enter their appearance to represent you, because you can't practice law without asserting and filing the proper paperwork. So,
Neither can you, ma'am.
okay, I'm not going to argue back and forth. You've asked me to rule on these issues. So I am not going to argue back and forth. What we do is I allow you to make argument, response, and then I'll rule. I am declining to hear from your person that's here today. I don't think it's relevant to the motions issues that have been raised. So,
Objection, Your Honor.
okay, I'll note your objection. Now what I'm going to do is, do you have,
Ma'am, can either overrule or sustain.
okay, I note your objection.
You don't note it.
I will note it, and I've already said that I'm denying you an opportunity to have your witness testify. So you can make a record regarding your objection, but I've already said that I'm not allowing him to testify. All right. So I just want to make it sure it's clear, Mr. Schmidt, do you have any other witnesses that you wish to call?
Not that you're willing to allow.
Okay, thank you. All right, the court's going to make the following findings in fact and conclusions allowed to rule on this matter. I guess initially, there's been some argument, so I just want to make sure that the record's clear on the jurisdiction of the court. I'm looking at 422126.5, and that is regarding some traffic laws, and it talks about that it uses the term Indians, means a person who's a member of a federally recognized Indian tribe. So Mr. Schmidt is asserting that he's a member of this federally recognized Indian tribe. The tribal code, including traffic provisions, governs the conduct of Indians within the reservation. When Indians drive, and this is a quote, and that's subsection 2.3. When Indians drive outside of the reservation, state and municipal traffic laws apply to their state driving privileges. So I'll just find that the court does have jurisdiction over Mr. Schmidt on this traffic case. So I guess I'll just go into the facts that I heard. So Officer Steiner testified that he's a detective for the Arvada Police Department. Sir, I'll let you make an argument. It's my turn to make a ruling. That on August 1st, 2025, he pulled over Mr. Schmidt and he identified him as the person in the courtroom. He pulled Mr. Schmidt over and then he didn't have a driver's license. He said he refused to give him his license, registration, and insurance. And he said that he wasn't his friend, so he wasn't driving, he was traveling. Mr. Schmidt wasn't being compliant and he said he'd like to speak to Officer Steiner's supervisor. So Officer Steiner complied with the request of Mr. Schmidt and called Sergeant Brown. And Sergeant Brown then reported to the scene and they talked for another 3 minutes. And then it appears that Mr. Schmidt then did comply with providing his license. He was issued a summons. He did not accept the summons, so they put that under windshield wiper. The court does find that there was reasonable suspicion to pull Mr. Schmidt over for the false plates. So to the extent, so I would find that Mr. Schmidt was pulled over. Then he requested a sergeant be on the scene, which prolonged his detention. And so I would find that in essence, he was requesting it. However, I do find that there was probable cause in that he had fictitious plates. He was refusing to give his information. And then as they continued their conversation, he had failed to display proof of insurance. And while he received a summons, there was sufficient probable cause to place him under arrest. As far as Miranda, that's a different analysis in that there must be custody and interrogation. Custody is more than not being free to leave. That looks like there's a case that says it's tantamount to arrest. And so the court finds that Mr. Schmidt was given a summons. He was not under arrest for purposes of a Miranda. So the court looks at those factors and finds that he was not under arrest or custodial interrogation for the purpose of needing Miranda to be read to him. I find that he was not in custody for the purposes of Miranda. So he was not subject to custodial interrogation. I'll find that all of Mr. Schmidt's statements were voluntary. So I am denying Mr. Schmidt's motions on those issues. Mr. Schmidt, I'll give you another 3 minutes to make any argument regarding that because it sounds like you have some disagreements regarding that.
Yes, ma'am. United States versus Pratzer. If an officer does not cite based on what he pulled me over for, he loses his opportunity to come back at a later time and cite me for anything else. Furthermore, where's the corpus delicti? I want to see the person that I harmed or injured. Also, I would like to see the contract in which I have signed my signature to obligating me to this. And again, I will bring up the unmarked car. Where in statute or federal law does it allow an unmarked car to pull over another car? I yield.
Okay. Any response to that? Okay. I made my ruling regarding under state law, and there is one more thing that I probably need to put on the record regarding travel. And that is, so while the right to travel interstate is without question a fundamental right under the Constitution, the critical inquiry in the case is whether someone's license burdens this fundamental right, and the Colorado Supreme Court has found that it does not. So requiring someone to be licensed or follow the traffic laws does not unconstitutionally burden someone's right to travel. So that's Henninger versus Charnes, CHARNES, 613 Pacific 2nd, 884. All right, so those are the constitutional issues I believe that we have handled. So, Mr. Schmidt, I just want to confirm you are set for jury trial on June 4th at 8 a.m. Have you picked up your discovery?
Still object, Your Honor.
Okay, I'll note your objection. I've already made my ruling. I'm not arguing back and forth.
I don't need a note. I need either
Okay,
overrule or sustain it.
I've already made a ruling on it, and you've made a record on your objection.
No, ma'am.
No, we're not arguing back and forth.
No, ma'am, I do not understand anything, but I do comprehend everything that you have said.
Okay, do you have any questions about your right to be represented?
I believe I've already answered that.
Okay, so these are required questions by law that I have to ask you, okay? Do you understand that if you cannot afford an attorney, one can be provided to you free of charge? Practically, I'll give you a chance to answer, but practically what that means is you have to make an application with the public defender's office. Do you understand that if you cannot afford an attorney, one will be provided to you free of charge if you take those steps?
Should I choose to do that? Yes, I understand that.
These are questions, again, that I'm required to answer or ask you by law. Do you have any legal training? Okay.
Plead the fifth.
Plead the fifth on your legal training. How far have you gone in school? Okay. So I need to just understand, do you feel like you have, I need you to answer some questions, or else I'm just going to find that you are making a choice not to answer these. I need to make sure that I am getting the questions asked under the law and that you need to answer them. And so saying pleading the fifth, I can't tell if you don't understand the process. And so that's what I'm going to keep asking you. But if you're just trying to use it as a game not to answer the questions, then I can make that based on the demeanor. I do feel like it's kind of this game you're playing with your friend that's here. So do you have any legal training? Yes or no?
Yeah.
Okay. How far have you gone in school? Are you under the influence of any drugs, medication, or alcohol that would affect your understanding of today's proceedings?
Do not understand anything.
So I'm just going to make a record for any appellate record that Mr. Smith's sitting here with his arms crossed. He's clearly not wanting to answer my questions. I do not think, based on my observations, that he's not understanding. I've allowed someone here to sit next to him who keeps whispering in his ear. It is clear to me that this is a strategy. So I just want to make sure that that's clear on the record. But I do think that Mr. Schmidt appears to be understanding everything here today. He doesn't appear to be under the influence of anything. He's been able to coherently answer the court's questions, but I do just want to make that finding. Mr. Schmidt, do you understand that criminal law is a complicated area and that an attorney trained in this field could be of great help in preparing and representing your defense?
Understand anything.
And again, I'll just make a note that I'm trying to advise Mr. Schmidt. I hope that he understands this. I think he does understand my questions, but he's making a point of not answering. Do you understand, Mr. Schmidt, the penalties that you're facing?
Understand anything.
Okay.
This goes for Indian tribal members as well.
I've already ruled on that. I'm not going to go back to my ruling on that.
What was that ruling?
You can order a transcript of the ruling. I found under the statutory requirements that someone that is a tribal member can be charged under the traffic laws. All right. So we'll see you back here. It is now, we'll see you back here on May 26th at 10:30. I've noted your objections. I've ruled on all of your motions.
That's not a ruling.
That's an ignore.
You're asking me to argue back and forth with you. Mr. Schmidt, you're asking me to argue back and forth with you. That's not how the court works. I've heard your legal arguments, I've heard responses, and then I've ruled. You want to continue this dialogue, and it's not a dialogue. I'm just ruling on it. I wish you the best, Mr. Schmidt. I'll see you back here for your pretrial readiness conference, and we will see you back here for that next court date. Thank you, sir.
As his next friend, counsel, I object to the fact that you refuse to rule on any of his objections. I find in the statute statute where you can sustain the objections, which I suggest you do, and I find where you can overrule those objections, which I know you will. Nowhere do I find where you can ignore or note an objection. It doesn't exist.
She
Get
abandoned,
away with it a lot around.
she abandoned.
But in federal court, it doesn't apply. Just not give you a heads up. We're gonna do federal district court.
Okay.
We're going to do Rule 27, acts of perpetual testimony.
All right.
You guys can get subpoenaed. Continue to prosecute. The cop says he never had prosecuted. That he didn't cite him for what he pulled him over for, which gives up the probable cause to cite him for any
I think that has all been ruled on.
case precedents.
Okay.
So
I look
give you
forward
some
to it.
job security, bro.